Welcome, students, to Constitutional Law, POS 475. Today we are going to continue talking about race discrimination, and we're going to look at cases where the court has applied strict scrutiny, and again look at some affirmative action cases that have been subject to strict scrutiny. We ended with a line of cases where African Americans were clearly disadvantaged, right? Ending with Brown versus Board of Education 2. That takes us to Loving versus Virginia. It was decided in 1967. This was during the Warren Court, and it was a 9-0 ruling. So, my dear wife Nancy is here as our class participation today. I like having someone to ask questions to. Since I don't have you guys as a class, I have Nancy. Nancy, what do you know about Loving versus Virginia?
They made that movie of it, that Loving movie.
Yes, they did. Appropriately named Loving. Right? So Virginia had a state law that outlawed interracial marriage, right? It's called miscegenation law, anti-miscegenation law. And the Lovings were an interracial couple, and they wanted to get married. So they went to Washington, D.C., got married, and then came back, right? Now, it's one of those things where you kind of hope on no one telling on you, no one enforcing it, but someone did tell on them. They were brought before a judge, and they were found guilty of violating the law, of leaving the state with the intent to get married and then coming back. So the judge found them guilty, and the trial judge had some interesting words to say. Sign of the Times, 1967, Virginia. He upheld their conviction, and he basically said you can go to 1 year in jail, or I'll suspend the sentence on the condition that you leave the state and not return for 25 years. So if you were the Lovings, which would you take? A year in jail, or leave the state and you can't return for 25 years?
I'd leave for 25 years.
Yeah, that's what they did. They left for 25 years. And here were the parting words from the judge. Almighty God created the races, white, black, yellow, Malay, and red, and he placed them on separate continents. And but for the interference with his arrangement, there would be no cause for such marriages. The fact that he separated the races shows that he did not intend for the races to mix. Right? So, that's who's hearing your case in 1967 in Virginia. That's your judge. That's who you're going to for some, for a hope of justice. Yeah, some sense of justice. And he says, God put the races on different continents, didn't intend for them to mix. And if people didn't mess around with that arrangement, we wouldn't even have need for laws like this. So, are you getting a lot of help from the local judicial system? No. So, the Lovings go to D.C., they move to D.C., and then they get the help of the ACLU, and they file a lawsuit, right? So, case goes to Supreme Court. It's the Warren Court. Warren Court takes it. Now, before the Warren Court took this case, did a lot of states, especially in the South, have laws like this?
Yes.
Yes. Did Alabama have a law like this?
Yes.
Yes. Pretty common, and again, it was just kind of accepted practice for a long time, right? It's not until 1967 that the state of Virginia is forced to go before the Supreme Court and is asked, why do you have this state law? Right? So if you are the state of Virginia, if you are an attorney for the state of Virginia, what do you argue?
I just don't even know how they even make a straight face.
Well, I know. Just,
Like, what did they say?
They tried to say a couple things. One is they're like, what do we say, guys? You got to meet with other attorneys for a state, and they said it's harmful for the children. Right? Children who are raised in biracial homes are going to be teased. They're going to be ostracized. They're going to be bullied. And so we have laws like this in order to protect the health, safety, and welfare of children. Right? See, usually the state is allowed to protect the health, safety, and welfare of children, right? But the thing is marriage a fundamental right?
Yes.
Yes, right? Even though it's not listed in the Bill of Rights, marriage is a fundamental right. And the court, ever since Meyer versus Nebraska, which we looked at, has said you have rights other than the ones that are listed. Among those, the ability to acquire useful knowledge, which was at issue in Meyer versus Nebraska. Another fundamental right they listed was the right to marry, and the right to have children, right? So marriage is a fundamental right. So the court said, no, protecting kids from being teased is not a sufficiently compelling government objective to justify interfering with somebody's fundamental right to get married, right? Are kids often teased?
Yeah, all kinds of parents were teasing.
Exactly. So kids are going to get teased, whether it's a bad haircut, the wrong type of blue jeans, their parents don't pack them the right lunch, whatever it is, kids are going to get teased. So court said, nope, that's not a sufficiently compelling government objective to justify interfering with the fundamental right of marriage, right? So Virginia, try another one, other than children. Try another one. Are you gonna try another one?
I don't even know.
Well, why don't you say what the trial judge said?
I didn't read the book.
God likes it. Well, I read it.
Well, I can't see how they would take that in front of the Supreme Court and think it was going to be a valid.
Yeah, you can't.
They weren't going to take what that judge said.
You can't argue that, right?
Right, they're not going to take that to the Supreme Court.
Yeah.
I don't know what else they took to the Supreme Court.
Yeah.
What else have they got? I mean...
Well, what else they have basically is that they tried to make the argument that it didn't discriminate on the basis of race because it applied to all races. Whites had to marry whites, black had to marry blacks, you had to marry within your racial category. So it didn't discriminate against a particular racial group. And the court said, no, we're not buying that argument, right? It is classifying. The fact that you have to marry within your race doesn't change the fact that this is a law that discriminates on the basis of race. It distinguishes on the basis of race. It takes race into account, right? So they said, we're not buying that argument either. Oh, it applies to every race. Every race has to marry their own. So nope, we're not buying that. Then there's always the old fallback. The majority doesn't like it. That's why it passed our state legislature. Seriously, and states are allowed to pass laws that the majority thinks are wrong. Certain practices are wrong. If the majority thinks certain practices are wrong, then they're able to pass such laws. And the court basically said, no. Again, not when you're interfering with a fundamental right. And to reinforce their argument, the court relied on both the due process clause of the 14th Amendment. You can't be deprived of life, liberty, or property without due process of law. So were they being deprived of the right, the liberty to marry the person of their choosing?
Mm-hmm.
Yeah, so it's a fundamental right, right? And the court also relied on the equal protection clause of the 14th Amendment, right? The two of them together. Because are African Americans a discrete and insular minority? Are they less than 50% of the population? Exactly, right? And so it's in Loving versus Virginia where the court kind of establishes, we'll let states regulate marriage, who can be married, that type of thing in general, but when a state passes laws that particularly disadvantage or are clearly targeted toward a minority group, someone that's less than 50% of the population, then it's up to us as the court to take a closer look at those laws, right? And, are states allowed to regulate marriage in a lot of ways?
Yes.
Yes, they are. A certain age, you have to be a certain distance away on the family tree. Those types of things. But when you're less than 50% of the majority, and when you're less than 50% of the population, when you're not a majority, and you're being denied a fundamental right, that's when the courts can take a cold, hard look at things, right? And so, I know we're in a different area of the law right now, but go back to Obergefell versus Hodges, the same-sex marriage case, right? Once you have Loving and Lawrence versus Texas as precedent, Obergefell versus Hodges is unavoidable in a way. It's going to follow, right? Because what is the state interest in outlawing same-sex marriage? Well, again, say you're an attorney for a state that has the law, like Alabama. I know you don't like having a legal mind, Nancy. Say you're an attorney for the state of Alabama, and we want to keep same-sex marriage banned in our state. What would you argue in front of the U.S. Supreme Court?
I don't know. What did they say?
Yeah, same things. It's harmful for the children, right? The problem is all the social science evidence suggests kids that are raised in same-sex households are just fine compared to other kids. Don't beat your kids. Don't do other things that are very harmful for them. But being raised in a same-sex household is not harmful for kids. So the social science evidence is not on your side there. That, we're protecting children. Then the argument that they tried to make in Loving versus Virginia, God doesn't like it. You can't make that argument, right? Can't make the argument God doesn't like it. The majority doesn't like it. When you're interfering with a fundamental human liberty, that doesn't cut it, right? So the court in Obergefell versus Hodges, in many ways, followed the same reasoning as Loving versus Virginia. It's the due process clause in conjunction with the equal protection clause that guarantees same-sex couples the right to get married. The two work together. And I think it's good reasoning. I was impressed. So Kennedy wrote the majority opinion in Obergefell versus Hodges, which a lot of people thought he would since he was the swing justice at the time. And he was assigned that opinion. So, all right. Any questions at all on Loving versus Virginia? Okay. 9-0. Right?
What was it?
Yes, 9-0. Right? So again, they're speaking with one voice. States, same as Brown versus Board of Education. States, you better get with the program. Because we're not changing on this. Okay. Now, that takes us to Bakke. Regents of the University of California versus Bakke. All right. This is an affirmative action decision that was decided in 1978. Nancy, what do you know about the Bakke decision? You didn't do your reading, Nancy? Okay. You do know a few things. Regents of the University of California versus Bakke.
Was this the medical school?
Yeah, this is the medical school one. Exactly. Right? So, first off, can the students see me here? Are all the UC schools good? Yep, they're all good. Just so you guys know, all the UC schools are good. So, UC Davis established a medical school in 1968, right? So, California, 1968. Do you think this school had a history of racial discrimination? This medical school that did not start until 1968.
Well, probably not.
No. It started in 68 in California, right? And it didn't have a history of discrimination, right? But it looked at its first couple classes, and it said basically, we're hardly getting any minority students, and all of them are Asian, right? We're just not getting many Latinos, African Americans. We aren't. So they came up with a new admissions program. And they said, here's what we're going to do. We have 100 incoming students in each incoming class. And so 84 of those will be kind of regular admissions. And then we're going to set aside 16 seats that will be filled through a special admissions program. And it'll be for people from previously disadvantaged groups, racial minorities, different racial minorities, Latinos, African Americans, Native Americans, that type of thing. And also, economically disadvantaged in some way, right?
Uh-huh.
Okay. So they put together an incoming class. And there were no white students that were admitted through the special program, the 16 seats, even though they claimed to be economically disadvantaged, right? They were just racial minorities. Well, there was this guy named Bakke, and by all objective measures, he was amazingly qualified, right? He got his undergraduate degree at the University of Minnesota. Let me make sure. In engineering. So he got an engineering degree from the University of Minnesota. He was a Vietnam War veteran. He worked for NASA. So the guy is literally a rocket scientist, right? He got his master's degree in engineering from Stanford. Stanford, is that a pretty good school? Yeah, so he gets his master's from Stanford. He's working at NASA. He's been in the military. And then he develops an interest in pursuing a medical career. So he takes a few more science classes. Does well, extremely well on the LSAT. MCAT, sorry, MCAT. He does well on the MCAT. His science GPA was really good. His overall GPA was really good. But he was not admitted right? He applied again the next year, and he was not admitted, right? So the people that were admitted through the special admissions program, their MCAT scores, overall GPA, science GPA, all you have to do is compare them, and they're clearly much lower than Baki. So how would you feel if you were Baki?
Be upset.
I would be, yeah, I'd be upset too, right? So he files a lawsuit, case goes to Supreme Court, and the Supreme Court said basically, okay, we're gonna apply strict scrutiny, right? Because this admissions program does discriminate on the basis of race, right? So this policy has to be the least restrictive or a narrowly tailored means of accomplishing a compelling government objective, right? Okay, so Powell is the justice that wrote, we need the cord, kind of like now. So, Powell wrote the majority opinion, and he said basically, well, he asked, what is the government interest? And the state answered, educational diversity. And they said, okay, we'll buy that argument that education is a compelling government objective. I don't know. Just 1 second, guys, while we plug this in. It's been on remote for a long time. So, just 1 second. Sorry. Technical difficulties. Okay, that looks like it's in. Okay, so Nancy, while you were gone getting the plug in, we good? What's happening now?
It's fine.
Okay. Okay, we good?
Yeah.
Okay, so while you were gone, case goes to Supreme Court. Yeah, it's fine. The court says educational diversity is a compelling government objective, right? But then it looks at the means used to attain it. 16 seats automatically set aside in a class of 100. Is that a narrowly tailored means of accomplishing the objective?
No?
No? Does it seem pretty arbitrary to you?
Yeah.
Yeah. Why 16?
Yeah.
Why 15? 18? 22? It's just 16, right? And so the court said, you have to come up with a better way of achieving educational diversity than just automatically setting aside 16 seats. That's arbitrary. It's capricious, right? There's not a tight fit there between the government objective and how you're going about it, right? So the court held up as an example the Harvard admissions program where race was viewed as a plus factor. One factor among many when trying to put together a diverse incoming class, right? So, what do you think of that ruling? What do you think about educational diversity as a compelling government objective? Right up there with national security, safety.
I mean, I think it's, pretty important, but, within reason.
Yeah. If you had to say what is more compelling, national security or educational diversity, okay. That's the point. Is some people looked at this decision and said, Whoa, come on. I mean, educational diversity is nice. I'll even give you important, but compelling is something that the government is forced to do, in a way. The government objective is compelling. National security, safety, right? Protection of property. Those are compelling government interests. Other interests may not be quite as compelling as those, right? So that was one criticism of the ruling. Any questions on that? Okay. So
did he get in?
What's that?
Did he get in?
He eventually got in. Yep. And went on to become, I think, like an anesthesiologist or something. But Backy, the aftermath. Mayo Clinic, free residency in anesthesiology. He then went into private practice as an anesthesiologist. By nature, a very quiet and private person, Backy never discussed his famous lawsuit publicly. He just, So an anesthesiologist. One more thing about this case. Again, since we're in no rush and we're just talking about constitutional law. So he got his undergraduate degree. He was in the military. Worked at NASA, got his master's at Stanford, took additional science courses once he decided he was interested in the law or in medicine. Guess what happened to Backy as he was doing all these things?
I don't know.
He got old.
Oh, yeah.
Right? And so a number of scholars have said, honestly, he wasn't the victim of race discrimination. He was the victim of age discrimination.
Yeah.
Yeah.
Well, I thought of that when you were saying that.
Right, exactly. You start going through everything. And see, here's another reason why I pointed out the UC schools. Are the UC schools all good?
Mm-hmm.
Yes. Given the quality of education, are they amazingly affordable?
Mm-hmm.
Yep. Given the quality of education, absolutely. Right? So, his medical education was going to be massively subsidized at taxpayer expense.
Right, and he's getting older, so how many years is he actually going to provide for the state?
Exactly.
Yeah.
So that's what the state of California is thinking, is if we're going to massively subsidize this guy's education, then we want a good return on our investment. And how do you do that? The older they are, the fewer years they have to practice. So you let in someone that's young. Yeah. Because if you
but
look
then
at...
if you're him, you say, look, I served our country, so...
I know!
Back.
Yeah, isn't that? Yeah, that's real.
Part of my getting old is serving our country.
Yeah. Exactly. Okay, so 25 years pass, right? And that takes us to a couple other affirmative action cases. Gratz versus Bollinger and Gretter versus Bollinger. Why is this Bollinger guy always getting sued? It's because he's the president of the University of Michigan. And Gratz versus Bollinger dealt with the undergraduate admissions program. And Gretter versus Bollinger dealt with the law school admissions program at the University of Michigan. So both 2003 cases, they were, basically kind of coming out at the same time, type of a thing. And everyone's like, oh, the court's hearing two really important affirmative action cases. I wonder what's going to happen, right? Okay, well, in Gratz versus Bollinger, the University of Michigan was trying to achieve educational diversity, right? Is the University of Michigan a good school? Mm-hmm. Yes. Do a lot of people want to get in?
Yep.
Yep. Do they get tons and tons of admissions?
Yep.
Yep. Thousands upon thousands, right? And so they just need a quick way of processing all these applications, right? It's got to be quick. You can't go through and read every tear-jerking essay. You just need some type of a point system. This much for GPA. The higher GPA, the more points. This much for SAT or ACT score, whichever they take. The higher the score, the more points, right? And so there were technically 150 possible if you were like the perfect student, right? But 100 was required for admission. And an automatic 20 points were given to any applicant from an underrepresented group. So in other words, 1/5 of the required number of points, right? And that turned a lot of heads, and people were like, that's a lot of points to be given, especially if you're a resident of Michigan. You're hoping your own kid gets in, right? So anyway, lawsuit was filed, case went to the Supreme Court, and the Supreme Court asked the state of Michigan, University of Michigan admissions program, what's your government objective here? Educational diversity, just like in Bakke 25 years earlier. Okay, we buy that. How are you going about that? Automatically awarding 20 points to every previously disadvantaged group or underrepresented group. And the court said, no. In Bakke we said you couldn't set aside 16 seats. And in your case, we're going to say you can't automatically give 20 points to every person. Is 20 arbitrary?
Yep.
Why 20? Exactly. Why 20? Why not 15? Why not 25? Why not? It's just arbitrary, right? And so the court said, we said, no, this is unconstitutional. So, again, educational diversity is a compelling government objective, but the way you're going about it is flawed. You're going to have to find another way of doing it, right? But this one's flawed. Then it looked at Grutter versus Bollinger. And in Grutter versus Bollinger, this is a little more sensitive. This is a little more ticklish, right? In Grutter versus Bollinger, well, first off, right off the bat, where do you get more applicants to? The University of Michigan's undergraduate school or their law school? Undergraduate, exactly, just because it's massive. It's just a huge university and tons of kids. Fewer to the law school. So the law school lends itself to individualized review, right? A holistic admissions process where you look at the whole application, right? And so that's what they were doing. So the University of Michigan Law School, they were looking at GPA, LSAT scores. What else do you think would be appropriate to look at when you're trying to put together a diverse incoming law school class?
Past experiences.
Okay, past experiences.
Gender.
No. Don't go that route. Because Grutter is actually female. Okay. Could you look at volunteer experiences?
Yeah.
Whether they speak a foreign language.
Yeah.
Yeah. Whether they've interned at a law firm.
Yeah.
Yeah. Whether they've been to law school camp.
Yeah.
Sure. Okay. Yeah. Why not? Point is, you have all these things, right? And they were using race as a plus factor, right? Well, did the court 25 years earlier say that was just fine in Bakke to use race as a plus factor as part of a holistic admissions process? Yeah, they did. And so in Grutter versus Bollinger, they upheld that admissions program to the University of Michigan Law School. They said, we said 25 years ago, Educational diversity is a compelling government objective. We stand by that still. We said that race can be viewed as a plus factor as part of a holistic admissions process. Individualized review, right? When trying to put together a diverse incoming class. And so we uphold Bakke. We stand by the reasoning in Bakke. And this type of admissions program is fine. Right? Now, a couple interesting things from the majority opinion. Bakke was decided in 1978. Grutter versus Bollinger was decided in 2003. That's 25 years. That's a nice, round, tempting number. So, Sandra Day O'Connor said, it's been 25 years since Bakke. And, well, let me backtrack for a second. By its very nature, what are affirmative action programs designed to do?
Promote like certain groups to getting
disadvantaged
in the past.
Overcome the effects of previous discrimination. Absolutely, right? So, are you less likely to? Let me rephrase this. Are you more likely to go to college if your parents have gone to college?
Yes.
Yes. Certain racial groups denied that opportunity.
Yes.
Yes, right? And so affirmative action programs were there to help overcome the effects of being previously disadvantaged, right? So Sandra Day O'Connor said it's been 25 years since Bakke. Affirmative action programs by their very nature need to be phased out at some point. About another 25 years ought to do it. So 2028. Yeah. 2028, yeah, apparently. And when I listened to Scalia lecture at Texas A&M, this got under his skin. I mean, he's just like, she just drew that number out of a hat. What if it had been 24 years since Bakke? You know, he was kind of mocking her. He's just, well, and is he right in a way? I mean, is it just random that it had been exactly 25 years since Bakke?
Yeah.
Yeah, and he's like, 25 years since Bakke. About another 25 ought to do it. And he was mocking her, and he said, and I'm at home every day, ticking off my calendar. You know, counting the days. Does that smack of a judicial ruling, or does that seem more like legislation?
Seems more like legislation.
That was another argument Scalia was making, right? Is judges rule on
the current case.
The laws, the current case, exactly. They don't, another 25 years ought to do it type of thing. So he was not amused by that.
Wasn't happy with Sandra Day.
Not happy, but she's pretty thick-skinned, so. Now neither of them are on the court anymore, so. But there's that. Okay, now, so now that we gave you the majority opinion and the majority's reasoning, let's take a look at the dissent because they bring up some interesting points. What does strict scrutiny mean? You scrutinize it, exactly. And what does it mean to scrutinize something?
Look at it closely. You
look at it closely, right? You don't just defer to whatever the admissions office is telling you, right? So, that's what scrutiny means. So, the court should have looked closely at what was going on, right? And by all accounts, this is what was going on. As the class is filling up and as deadlines approached, say say the state of Michigan is about 13% African American, right? And say only about 6% of their incoming class is African American, right? Then, as the class is filling up and as deadlines approached, what do you suppose happened to race as a plus factor?
Goes up.
Yeah, the thumb is on the scale more and more. And they're like, we need, race is more of a plus factor now than it was 3 months ago, right? Then say the state is 6% Hispanic and you already had 6% of your incoming class Hispanic.
So much.
For some reason, it doesn't matter so much, right? And so the court looked at the evidence. The evidence was the evidence was the admissions office was fluctuating, absolutely.
Fluctuating with how much they were
viewing it as a plus factor. Exactly, right? And that's what the dissenters said is this is a sham, right? And they said basically this is a quota system, right? Because that's what they were trying to do. And when you look at the numbers, they were trying to
have it proportional to
the state's population. They were trying to have a proportional state population. Exactly. And the court has said regularly, except, in just very few circumstances, are quota systems allowed. Make sense? Mm-hmm. Okay. So, next thing, the state also said they need a certain number of minorities so that there would be a critical mass. Right?
The state said this?
Yes.
Oh, the university.
Yeah. The admissions program, right? University of Michigan admissions program. The state. They said we need a critical mass of minority students in order to get a robust exchange of ideas, right? Would you want to be the token Hispanic person in a class?
No.
No, why not?
Because then you just get every question towards any kind of towards you.
Right. And maybe you don't want to do the heavy lifting that day, right? Also, there's no one to kind of back up what you have to say. It's like, yeah, I've had a similar experience, or anything like that. And so they said, we don't want just a token representative from different minority groups. You need a critical mass so that you can have a robust exchange of ideas, right? Okay, well, again, strict scrutiny. That means you scrutinize things. And Native Americans, they made up, 1% of the incoming class, whatever it was. Hispanics made up, 5% of the incoming class, whatever it was. African Americans made up 10% of the incoming class, whatever it was. And the dissenters said, okay, all right, you say it's not a quota system. Then tell us how do you get this critical mass from 1% of Native Americans, but you need 10 times that, 10%, in order to get a critical mass from African Americans.
Yeah, doesn't make sense.
So again, the majority said the admissions office has told us how many students they need in order to have a critical mass. We will defer to them, right? The dissent said, if we're just going to defer to whatever the state says, then what do we even mean by strict scrutiny?
Yeah.
Scrutiny means to scrutinize something. And so unless we're intent on just giving the state a free pass in all these situations, then we should fulfill our responsibility to look closely at something and see if it actually passes constitutional muster. So what do you think? Who has a better argument in this one? The majority or the dissent?
The dissent, yeah.
It's difficult. Yeah. Students, your dissent paper is over, but I could have written on this one. But it's an interesting case, right? Okay. And I think educational diversity is very important, but I also think it's important to go about it the right way.
Then just backfires.
Yeah, then just leads to backlash and problems. Okay. Now, we have a couple more minutes, so let's discuss where you go from here, right? So, if you're the University of Michigan, if you're the University of Texas, right? You don't have time to read 10,000 essays, right? So you don't have time to use race as a plus factor as part of a holistic review, right? So what do you do?
Well, didn't Texas just go to the top 10% of the class?
That is exactly what Texas did. They adopted what was known as the top 10% plan, right? And what they did was they said, if you graduate from the top 10% of your class from any public school in the state of Texas, then you are guaranteed admission at any public university you want in the state of Texas, right? So when I did all my educational research down by the border, down by Brownsville, areas like that, I walked into schools that were 100% Hispanic, just because the area was 100% Hispanic, right? So guess what was the racial makeup of the top 10% of their graduating class?
It would be 100% Hispanic.
It would be 100% Hispanic. Exactly. The top 10% were 100% Hispanic. So, are they guaranteed admission at the University of Texas, Texas A&M,
Yep.
other outstanding institute? Yep, you're in. And does your race need to appear anywhere on your application?
Nope.
Nope. So, race doesn't need to appear anywhere on the application. It is race neutral. So, in a little bit. Just a little bit. So, it's totally race neutral, right? And does it allow them to put it together a diverse incoming class?
Uh-huh.
Yes. Okay. Now, the problem was Texas was doing that. Matthew, please just give us... Yeah, a little after 4. A little after 4. Texas was putting together their class that way. Jeez. Texas was putting together their class that way. And they still had seats to fill. And so guess what they fell back on?
Quota system?
Using race as an admissions criteria. Right? Exactly, right? And so another lawsuit was filed.
Girl.
Yeah, it's Fisher. Fisher versus University of Texas. And they said you're still using race. So the case went to the U.S. Supreme Court, and they looked at the plan, and they said where viable race-neutral alternatives exist, then you need to use those before you start taking race into account, right? So if the top 10% plan didn't fill your incoming class, guess what you could do to get more students?
Maybe go the top 15%?
It's not rocket science. So maybe instead of top 10, you make it top 11, top 12. Does that allow you to
Keep it race neutral, yes.
keep it race neutral? Yes. Assemble a diverse incoming class?
Yes.
Yes. Now, I will tell you, as a professor, I got my PhD at Texas A&M. I taught there for 1 year afterwards. Unfortunately, a lot of the students that get in under those top 10% plans aren't necessarily prepared for college or are going to succeed at college because they're from schools that prepare them very weak academically. So even though you graduate in the top 10% of your class,
you're in the bottom 20% of schools.
Yeah, exactly. Yeah. But anyway, then another lawsuit was filed, and it's back and forth, and we're still hammering these things out. But according to Sam Day O'Connor in Greta versus Bollinger, 2028, we're done. So take care. Hope you guys are doing well. Bye-bye.